Oh, I'm sorry.
That's all right.
Right over here, and then back there.
Professor Chai, James Mitchell. I want to get your commentary on what I think is a relatively recent phenomenon, what I'll call the politicalization of judicial appointments, particularly at the Supreme Court level, but now we're even doing it at the appellate level of the federal court. I think most people in this room would agree it probably started or escalated with the Robert Bork nomination. But it seems nowadays one of the things presidents look for in a potential Supreme Court nominee is someone who hasn't written very much. David Souter perhaps being the most extreme in this case. And people like yourself are willing to kind of express their opinions on all kinds of subjects. Therefore, if you were, or someone like yourself were to be nominated, become sitting ducks for whoever.
Oh, I haven't. Just 100 books. That right. I couldn't find anything to quarrel with in those 100 books.
And so it seems to me a phenomenon that encourages people who haven't at least publicly expressed themselves on issues. Those are the kind of people we want to nominate to the highest court. It's not necessarily a long-term the best way to deal with things. What do you think? Comment about this, and if there's what kind of solution is possible?
Well, it's a very hard and a very important question, to which I should say right off, I don't have a very good answer. I will say that it's not all that recent a phenomenon. That is, I wrote a book in 1985 called God Save This Honorable Court, How the Choice of Justices Shapes Our Country. And it was a book that was written before Justice Powell left the court and before the brouhaha of the Bork nomination. And what I found was that, in fact, throughout our history, there have been lots of times when the debate over a justice was extremely politicized, and in a sense, properly so, because the only chance that people have to express a constitutional philosophy is at the time of a nomination to the court. I mean, once someone gets on the court, that's a lifetime seat. So that when Robert Bork was nominated, he had a well-developed philosophy, one that said the Ninth Amendment, the text of which I summarized for you earlier, was basically, in his words, an ink blot on the Constitution. It didn't really mean anything. It was a view that a number of people, including me, found threatening, so I ended up testifying for 3.5 hours against Robert Bork, saying I thought he was a very smart man, a very nice man, but that his views were ones that I thought the Senate should find unacceptable. I think in the end he was rejected not because of anything I said or other witnesses said. He was rejected because his own testimony generated a kind of firestorm of national protest. People thought these are not views that belong in the court. It was a kind of national referendum on the Constitution. And it's true, too, that if someone who's very liberal was nominated, and if the country is much more conservative, there would be a similar national referendum that might go the other way. But I think in a sense that's proper. What's improper, what's unfortunate, is digging through someone's email trail. Some people tried to look in Robert Bork's trash to see what stores he had rented videos from. The same thing was done to Clarence Thomas. It's kind of gone overboard in that respect. That's part of the ugliness and sort of partisan deadlock against which I inveighed near the end of my speech. It's very hard to imagine exactly how to unwind that, because neither side, if you imagine it simplified just into a left and a right, neither side wants to engage in unilateral disarmament. Neither side wants to stand down on the mere promise that the other side will act nice as a result. So you may be right that the net result is that we're going to get more and more so-called stealth nominees. And that makes it all the more important that people vote for a president whose selection of nominees, based on everything we know about that president's constitutional values, is more likely to accord with our own. Right now, the only justices who are likely to leave in the next few years are liberal to moderate. Stevens, who's almost 89, Ginsburg, who's not all that healthy and is 75, Souter, who's only 67, I think, but who hates Washington and wants to go back to the cocoon of New Hampshire. Whereas guys like Alito, 57, and Roberts, 53, those are the youngsters, the young Turks. They're going to be around for a long time. If Obama becomes president, we're likely to have someone like Stevens or Ginsburg or Souter replaced by someone like Stevens, Ginsburg, Souter, Breyer. They'll probably not be people who are flamingly liberal in their writings, because that would generate a firestorm, unless the Senate is itself so much more liberal that they would be confirmed. If McCain becomes the president, he's already made clear, he's made a commitment to his base that he will appoint people like Scalia, Thomas, Alito, Roberts. There's likely to be a Democratic Senate. He won't likely succeed in appointing people who have a very clear paper trail showing that they would overrule Roe v. Wade. But each president is likely to have much better access to the philosophy of a potential nominee than the Senate could ever get. That is, the president is likely to know the individual, be able to find out about that person, have a fairly good sense of how that person would approach the hot-button issues, at least of the foreseeable future. And the Senate is not going to be able to prove the contrary. And so I think it's likely, if McCain is president, that there will be a shift in the court, which is now hung by a very narrow 5-4 balance on dozens of key issues of executive power, separation of church and state, affirmative action, personal privacy. So it makes a huge difference. And the confirmation process probably can't be counted on to illuminate very much. We are likely to have people who have written relatively little, who've been quite cautious, whose minds are known mostly to the appointing authority, which makes the election of a president, especially at a time like this when so many issues hang by a 5-4 balance, a matter on which constitutional philosophy, the constitutional philosophy of the president, makes a great difference. And we know a lot about the relative constitutional philosophies of these two guys. One of them, Barack Obama, has taught constitutional law. When the Supreme Court this summer said that the people that we lock up in Guantanamo on the ground that they are enemy combatants deserve at least habeas corpus, some hearing at which we can explore, not necessarily with all of the fancy rights, not necessarily with Alan Dershowitz as the defense counsel, but sort of figure out if there's been some mistake. Maybe they were just wandering around and picked up. A lot of people seem to be picked up by mistake. 5-4, the court said that they had that right. John McCain said he thought that was one of the worst decisions in American history. Think about it. Compared to Dred Scott enshrining slavery, Plessy v. Ferguson enshrining racial segregation, Lochner v. New York holding that the government can't pass minimum wage or maximum hour laws. This was one of the worst. Barack Obama said it's one of the best. The power of our example abroad is stronger than the example of our power. That what we stand for as a country is not simply assuming that somebody is an enemy combatant and locking him up and throwing away the key. Well, we know something about the two different competing constitutional philosophies. And it's on that basis, more than on the basis of what the confirmation hearings show, that we will probably, if we care about those issues, need to make something of a choice.